Hi, Commissioner. We're unable to hear you.
Okay, there we go. Sorry. All right, we'll start again. Sorry. I'm Commissioner Joe Ketsis. We're here in the matter of Clayton Echard. Am I saying that right now? Echard, sorry, versus Laura Owens. This is CB 20230533952. We'll begin by having everyone state their name. Mr. Echard, if you can state your name for me.
Clayton Echard.
All right, counsel?
Yes, Your Honor. Attorney Joshua Lopez representing Laura Owens, who's present via Microsoft Teams.
Thank you, Ms. Owens. If you can state your name for me.
Laura Owens.
All right, thank you. We're here today regarding the pre-issuance hearing on a petition for an injunction against harassment that was filed by Mr. Echard. And so we have an hour and a half for the hearing. That means each side has about 40 minutes to conduct their case and their testimony. So you do want to make sure you're being conscientious of what you want to present in the time that you have available. We do have a number of exhibits. And so if you would like to use an exhibit or admit an exhibit, then you do need to lay some, what I'm going to call foundation for that exhibit, which means you need to tell the court what the exhibit is, if there's a specific date and time that relates to that exhibit, how you have knowledge of the exhibit, and how it's relevant to what we're doing. And then you need to actually move to admit the exhibit. If you want to present an exhibit, you have to, once you've laid that foundation, you have to actually move to the court to ask to admit the exhibit. Just because you submitted them doesn't mean they come into evidence unless you move to admit those, okay? And then you'll have the opportunity, so Echard, you're going to go first because you're the plaintiff. You'll present your case and your testimony, and then the other side counsel will have the opportunity to question you, and then they can call witnesses and you'll have an opportunity to question them. And then at the end, everyone will have an opportunity to make a closing argument, okay? The things that people can testify about, you do need to make sure that they are related to something that you have personal knowledge of. So you can't just say, I saw something on the internet, and so now I can testify about it. Okay, it does need to be something that you have some personal knowledge about. And I know that this case also has a family court matter. This is not the family court case. This is not the trial on the family court issues. So I need everyone to focus on the issues that we have for this hearing. So we're not deciding pregnancy issues, we're not deciding paternity issues. Those are not the issues that are going to be decided today. So what this court is looking for is a determination as to whether or not there were a series of events that were aimed at a particular person that would cause a reasonable person to be annoyed, alarmed, or harassed, that person was in fact alarmed, annoyed, or harassed, and that those actions had no legitimate purpose. Those are the findings that the court is looking to make. So, Echard, for you, you're trying to show by preponderance of the evidence that that was the case. And then, obviously, Ms. Owens is going to be trying to show that there is not a basis for the injunction. So the things that are outlined in the petition are the things that can be discussed or addressed, okay? But as I said, we're not discussing whether or not officially that there's a pregnancy or whether or not officially there is a paternity issue, okay? So we need to make sure that we are keeping on track with what we want to show in our case. And so the series of events does need to be more than one, but it can be over any period of time. So those are the things that we're looking for. Does anyone have any questions about what I've just gone over?
Your Honor, I have a couple questions.
Okay.
Did you want to hear opening statements?
I mean, I would allow people to do an opening if you wanted to, or you can waive openings either way.
Okay. And my other question is that what I believe that Mr. Echard is going to present are emails regarding alleged harassment in this matter. But the emails, and I know you had indicated that, and I understand this is not the family law, the family court case, but the emails and the alleged harassment have a lot to do with paternity and things of that matter. So I think that those things are going to come out despite this not being us trying to prove paternity and things like that. I think the content of the emails has to do with that, and so those things will come out.
And I understand as they relate to the specific basis for the communication,
Okay.
that they can be brought out. I just don't want the parties to think that I'm going to be making any determinations as it relates to those other issues.
Thank you.
So do either party wish to make an opening statement?
No.
Or we can just begin with the testimony.
Present my evidence.
Your Honor, I'd like to make an opening statement.
Okay, go ahead.
Your Honor, you're going to hear that back in May of 2023, Laura Owens and Clayton Echard became intimate, which led to my client becoming pregnant with twins. And since May of 2023, Clayton has refused to believe that my client became pregnant. He's refused to believe that he's the father of these unborn children. And he has refused to work with my client to create a plan on how and if he wants to be a part of these future children's lives. Instead, Clayton turned to the internet. He's turned to his fans. He's turned to his followers, and he's spread rumors and lies about my client. Clayton has insinuated that my client lied about being pregnant. Clayton posted online about legal issues he knew little about regarding my client, Laura Owens, and a legal battle that she was involved with and is still involved with another individual. Clayton has posted about Laura that has led to harassment by his fans and followers. Laura has received harassing messages. Laura was asked to kill herself, and Laura has been staying inside to protect herself, which is why she's currently appearing via Microsoft Teams for this particular proceeding. And again, this all stems from Mr. Echard's post online. All communication from Laura to Clayton during these time periods that Mr. Echard put in his petition has been related to Laura's pregnancy with Mr. Echard's unborn children. It's also been related to what Mr. Echard would like to do moving forward with the unborn children, creating a parenting plan, and actually it's also in regard to potentially him taking down posts, which again led to harassment by his fans and followers. None of the communication that Laura directed at Clayton was for harassment purposes. All the communication was for legitimate purposes, and a reasonable person in those same circumstances would not be seriously alarmed, annoyed, or harassed by that communication. And at the end of this hearing, we're going to request that the injunction against harassment be dismissed or not issued. Thank you.
So for testimony purposes, Mr. Echard, I'm assuming you're going to be testifying, and then Ms. Owens, I'm assuming, is testifying, counsel.
Ms. Owens will be testifying, Your Honor.
So if I can have you both raise your right hands, you can be sworn in for me.
Promise swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Yes.
You? Okay. All right. Mr. Echard, if you want to go ahead and begin with your presentation of your testimony.
Thank you. I think it is important to just provide a little bit of context for that opening statement. It is what he had stated. I do not believe that Laura is pregnant. I know we're not here to discuss that today, but because of the evidence I will present, I will explain why I've been receiving unwanted messages for the last 5 months, and I have blocked this individual from all communication, yet they continue to send me messages. And I have asked this individual to early on do a paternity test, and she said she would not do it unless I were to date her exclusively. And so then Ms. Owens threatened to go public, which I have submitted that evidence today. But my reasoning for why I doubt her and why I have chosen to cut off all communication is because, if I can submit Exhibit 32.
And what is Exhibit 32?
So Exhibit 32 is an ultrasound image that I was sent via email by Laura. No ultrasound report was provided, and when I asked to speak with a doctor, she would not allow me to talk to that doctor. We also did an early resolution conference. It was in the last couple weeks. The mediator asked for her to make that phone call to that facility to prove that she did have to do this ultrasound. She did not do it. She was not willing to make that phone call. And so with that picture and that picture alone, I believe it is photoshopped, and there is no report that she has been able to provide. And I've asked for it, and I would like a doctor to be able to stand behind that image, as I believe it's a fraudulent medical record that she has submitted to me via email.
Okay. Are you moving to admit Exhibit 32?
I would like to admit, yes, Exhibit 32.
Any objection?
Yes, Your Honor. If I'm not mistaken, Exhibit 32, double check. You know what, actually, Your Honor, I'm not going to object to this.
All right, 32 will be admitted.
Thank you. May I continue?
Okay.
I would also like to admit Exhibit 36, the flash drive.
Before we get too much further, if you can just explain to me what you believe your relationship is or was with Ms. Owens, because part of the reason it's an injunction is because of the relationship nature of it. I think that you listed as being not an intimate relationship. So I guess maybe if you can clarify that for me.
Yes, Your Honor. Laura and I had engaged in oral sex one time. And to me, as I filed this, I did not believe that constituted a relationship of any kind, as it was a one-time thing.
Okay, thank you. All right, go ahead, sorry.
Exhibit 36, I would like to admit that as well. This is a flash drive file. This was also sent to me by Laura Owens via email. She, in this email, which I actually have, can I submit multiple at one time or no? Or reference them at least for now?
Okay.
So Exhibit 18 is a screenshot of the email that she had sent me with this ultrasound video that she claimed was, you can see on there, I don't know, 1,000,000% real ultrasound video. She's claiming that that was the ultrasound of our children. But then I uncovered the Exhibit 34. This is a YouTube video from over 6 years ago. And that video has the video that she sent me within it. And so Exhibit 36 is the video that she sent me and then the video on YouTube. And as you play both of them out, you can see that they are identical videos. She had cut a portion from the YouTube video and claimed it to be her own when it was somebody else's. And so I would like to, I'd like to admit at least Exhibit 36, but also 34 and 18 to prove that she did in fact send this to me via email, and as 18 and 34 show. but also then to admit 36 because that is the visual proof that these videos are identical.
Any objection to 18?
Yes, Your Honor. I don't think there's enough foundation for the different things that Mr. Echard is stating. It sounds like something was sent to him, and I don't know what websites that he's going to get these. And the things that he's claiming in here, he's saying that these are identical. I don't know if he can testify that these are, in fact, identical.
Okay. So 18 appears to be kind of a screenshot of almost similar to 32, but I think it's closer to matches 34. But I think 18 is the one that actually was sent to him. Is that correct?
That is correct.
So do you have a specific objection to 18? Or objection?
That's what was sent
more related.
Yeah. Wait, 17, 18.
18, I think, was the one that was sent to him. So do you have something specific about that exhibit?
I mean, maybe just some foundation regarding who it was sent from and how he knows. Got it.
So, Mr. Echard, if you can just outline for the court specifically the way that you received this.
Yes, I was sent this by Laura Owens. As you can see in the screenshot, this was sent from her.
What date?
The date of it was October 6th at 4:39 p.m.
Any objection to 18?
There you are.
18 will be admitted. And then 34, give me more information about when and where you received this document.
So Exhibit 34, I uncovered as I had questioned the validity of Exhibit 18, what she sent me. I did not believe that it was in her ultrasound. So I started to look online, and I found this YouTube video. And upon playing it, I found that the video that she had sent to me is within that YouTube video.
Okay. Objections to 34.
There you are.
34 will be admitted. And then objections to 36.
There you are.
Right, so 36 will be admitted. Echard, if you want to continue.
Yes, I would like to. I would also like to discuss Exhibit 30. So Exhibit 30 entails a prior court case with this individual. And the reason why I bring it up is because of the repeated or similar patterns of behavior that Ms. Owens has exhibited. In this exhibit, there is an ultrasound in which she presented to this individual, and then it was found that through a reverse Google image search that she had taken that from online as well. In this case as well, she states that she became pregnant by this individual, and she also claims that she was became pregnant with twins after one sexual encounter. And so the parallels between my case and this individual's case, I think, is important to bring that to light and admit that as well, because this individual has displayed repeated patterns of behavior. And I think that's important to note as to why I question the validity of this individual's claims.
And where did you obtain this document?
I obtained this document from this court. I came in here, it's publicly accessible. So I came here and I searched it, and there's about 14 pages in this that I printed off. There's more in the court system, but I consolidated it to bring out the documents that referenced similar instances. And so This individual that she had brought this claim against also questioned if she was pregnant or not. It does state in here that she provided sonographic images, and then a reverse Google image search revealed the images were identical to a sonogram found on a blog post from 2015. And then within this document, it shows the pictures that were submitted to the court, the ultrasound in question. And then I'd also like to bring to, in this document, in the picture, it says that she'd sent to him, it looks like you're going to be a dad to 1 or 2 babies. And so she again states that she was pregnant with twins with this individual. And then on one of the last pages of this document that I had pulled out, it was noted in this court case, the plaintiff reportedly fabricated a pregnancy and subsequent abortion in the past during a relationship with a Michael Maricini in 2016. I do not know the specifics of all of these cases, but I do want to bring this to light and submit it admit the exhibit because of the repeated patterns of behavior that I think are important to note, because contextually speaking, that is part of the reason why I will then present my evidence towards why I feel I'm harassed, because I do not believe what this individual is stating. I don't believe anything that she's saying, and these are the reasons why.
Your Honor, I'm going to object to this being entered. This is an ongoing case. We don't know what claims are or are not true within this exhibit. I don't think that it's appropriate, and I don't think that it's relevant to Mr. Echard's petition in this specific matter.
So one of the allegations is a pattern of behavior of accusing men of getting pregnant in his petition. So I guess that's what he's presenting it for. So hang on, Ms. Owens, just a minute. I think that's one of the allegations in his petition, but
again, Your Honor, this is an ongoing case. We don't know what the result of this specific case regarding this exhibit is. We don't know anything about this case. We have it looks like this is some sort of complaint. It looks like it's a motion to dismiss, I'm sorry. Or there's several documents here. I don't think that this is relevant for this particular case. I think that this is speculation. These are claims that other people have made. I think this is hearsay. I don't think it's admissible for this type of hearing.
all right. So I'm not going to be able to admit Exhibit 30. I do agree that this is a complaint and a motion to dismiss, but whether or not there's significant information enough to be able to support that, and whether you have any knowledge of it, is I think I'm not going to be able to admit that exhibit. Ms. Owens is raising her hand, but your attorney is here. So did you have a question?
No, he covered everything.
Okay. And he's going to be speaking on your behalf unless you're testifying. So
I would like to testify.
You don't have your chance to testify, but you can't testify in the middle of his testimony, and then your attorney needs to be the one that speaks on your behalf unless it's your testimony, okay?
Okay.
All right, Mr. Echard, anything else?
Yes. Now I'd like to go in and admit each of these documents, and I have them set in an order. So the very first one, Exhibit 1, this is just showing all of the files that I have accrued. There's often 2 to 3 emails that she sends me a day. She started sending me emails, harassing emails on the 6th of June, and she is still sending me emails as of yesterday. And so Exhibit 1 is just showing the frequency of her harassment from a bird's eye view.
And so when you get the email from her, tell me how this gets created.
Yes, so when she sends me emails, I screenshot them and then I place them into these files so that I have them for a record. Okay. Any objection to Exhibit 1?
Yes, Your Honor. Again, I don't think that the frequency of emails is something that would indicate harassment without something more. If there's communication back and forth between emails, then the frequency of how many times somebody sends an email, I might send 60 a day, but the frequency of emails between, I believe, May to now, and I don't know how many these are. We don't see the emails in here. There's nothing to say that this, in fact, is harassment within the meaning of the statute. So for those reasons, I'm objecting to this being admitted.
All right. Over the objection, I'll admit Exhibit 1.
Thank you. Can I continue? Exhibit 2, a lot of these next exhibits are all going to be phone numbers that Laura has contacted me from. She has contacted me from 13 different phone numbers, and I finally stopped blocking the 13th one because I knew that she just would continue to create a Google Voice phone number. And so this first one, it says in the text message, it's Laura, I need please unblock my, and then she shows her number. That was her original number. And so I would like to admit these one by one to show again the many different times that she has continually contacted me after blocking her from different phone numbers.
And so this is a text message from when, do you know?
Unfortunately, I don't. It just says text message from today. Again, I was screenshotting these as I received them. I received these over the last 5 months. As far as what exact day, I'm not right now. I'm not aware, and I don't know if there's.
Can you approximate when this message came in, or you don't know?
To be honest with you, Your Honor, as far as when this one came in versus the other ones, I don't know. This one says, I have it down here as her blocked cell number 12, so this is probably one of her last ones that she had sent to me. And I would say that I think this one came through probably about a month ago, because since then she resorted back to sending me emails because she put a mail tracker on the messages. So she was able to see when I was reading them. But during this period of time, when she was sending these text messages, I was not opening her messages. And so she knew through her mail tracker that I wasn't reading them. So she decided to go about the Google Voice manner in order to get them to me, because she could see that I was not opening her emails.
Okay, so you have this one you believe is from one of the 12, at least one, the 12th message, that as well cell phone number that she was using.
Correct, yes. Each of these came from Laura, yes.
Okay. Any objection to 2?
Yes, Your Honor. Again, Mr. Echard must show that there is harassment. When I look at this text message, I don't see anything that is even remotely close to harassing here. It's a text message indicating to him that they're having a boy and girl. She has an ultrasound to show. I just don't see anything in here that is even related to the petition itself that shows that this is harassment, that he was annoyed, alarmed, harassed in any way. This is simply a text message.
Well, I mean, part of his, petition is the high volume of those, and that ultimately he can testify whether he was annoyed or harassed by these. So I'm going to admit Exhibit 2 over the objection.
Thank you. Again, Exhibit 3, just to make this, again, I want to be respectful of everyone's time here. This is, again, another cell phone that she had contacted me from, so I'd like to admit this one as well for the same reasons as Exhibit 2.
Your Honor, it sounds like there's going to be a number of different cell phone screenshots submitted to the court, and I just want to make record straight that I am objecting to all of these based on the same reasons I was objecting in Exhibit 2. So,
okay.
So I don't have to just repeat myself over and over again.
All right. And so, this Exhibit 3 it has that similar language to please unblock the original number. So you're telling me this came from Laura, but from another blocked number.
Correct.
All right. I'll admit 3 over the objection.
Thank you. 4, also sent from Laura. This one says that she couldn't get into Google Voice, had to make a new number. So again, this one just shows that she was in fact using Google Voice and creating more and more numbers in order to harass me. And yes, I did feel harassed because I did not want these messages. This one you can see I did respond to, and what I said is how I felt. I was asking for her to schedule the paternity test, which she continuously declined unless I were to date her exclusively. But for the purposes of this text message, it was another unwanted text message that she had sent my way.
So tell me a little bit more about the dating thing, what you're telling me when you say that.
Yes, so you can see this in this exhibit here. She said, guessing you won't read this, but I made you a pretty good offer. Meet up tonight to discuss the pregnancy and the possibility of dating. But regardless of the outcome, I will schedule a test with Rabgen tomorrow. So her stipulation for taking a paternity test early on has always been that she would only do the test if I were to date her exclusively for 2 weeks. Then she dropped it to a week, and I did not agree to any of that. I simply just said, as it says in here, drop the dating stipulation, schedule the test, pay for the first part of it, then email me when you schedule it, and I will schedule my part. So I had continuously tried to figure this out, and she would not do the prenatal paternity test unless I were to date her.
And this Rabgen is the?
Rabgen is it is the facility that provided the test so that you can test for a prenatal paternity test for twins.
Okay. All right, I'll admit 4 over the objection.
5, again, is another text message from her again, saying that she doesn't know how to use this app. She's referencing Google Voice. She said, I'd like to meet, no strings attached. I did not want to meet with her. She's asked me to do multiple times. I do not feel safe meeting with her because I'm not sure what she would claim if we were to meet up. I don't have any reason to meet up with her. So this is another text message that she sent me that was unwanted and very harassing.
Over the objection, I'll admit 5.
6, again, another text message says she should change her number. I would like to admit this one as well for the same reasons as the previous messages.
All right, and this is another different number than previously used.
Yes, and then in this one, I would even just like to highlight, she said she threatened to leak this to the media, which I will be admitting in evidence for that, but she threatened to go to the media, which she ended up doing. This text message just proves that she was, again, looking to defame me through basically whether we date or leak this to the media. She threatened me to go to the media with this text message, amongst other times she threatened me.
All right. I'll admit 6 over the objection.
7, similar thing again. She stated this time she would do it with no strings attached. I had then responded by saying, let's schedule the paternity test regardless. But she was asking for this agreement and that we needed to meet up for a good faith consultation. Again, I did not feel safe meeting up with her one-on-one, so I disagreed with this. But this is another text message that she decided to send from a different number. These are all, as I can just to reference, these are every single one of these, as you can see at the top, they're all different numbers. So these are all coming from a different number every time.
I'll admit 7 over the objection.
Another text message, she just states that she sent an email to Rabgen, and then she threatened, you want me to go to the public instead of meet up? So those were the options. Either we meet up or she goes public with the information.
I'll admit 8 over the objection.
9, another message that I didn't block. As you can see, she sent multiple messages before I decided to block her. And she was asking for a good faith consultation. Again, she was trying to meet up with me. For what reason, I can only speculate, but I did not feel comfortable doing so. And so this is another phone number that I ended up blocking.
And And can you elaborate on what it says? I just made what I think is a very enticing offer. What that means?
So to be honest with you, I don't remember exactly what her offer was. She made multiple ones, but they all centered around a very similar, if we meet up and we try to date, it was 2 weeks, and it became 1 week, then it became just meet up for this tonight, this good faith consultation. And she would make a lot of promises as far as once we do this, then I will go take the test. But again, I did not feel safe being with her one-on-one. I did ask actually to meet up with in the courts, or I said we could even meet up. At one point I said a coffee shop with people around, and she declined that and said, no, we need to meet up in private. So I said no to that, and blocked her again on this phone number.
All right, I'll admit 9 over the objection.
Again, 10, this is another phone number. She mentions going dark on her, which is a reference to me not responding to her. Again, just to highlight that she has been consistently harassing me with me not responding to her for the large majority of these messages. The only time that I was often responding was to try to get a paternity test scheduled. Outside of that, I did not. I had little to no interaction with her. And so at this point, she references here, I will cancel the Rabgen appointment. She had scheduled one, paid the $750 for it. But then in the past, as she had stated she had scheduled it, she would end up canceling these. So it was just a show on her side of things to state, yes, I'm trying to do this test. But when it came down to it, she always placed stipulations whenever I responded to her. So at this point, when she said I'd spend $750, I did not respond to this and blocked this phone number because I was not taking any of what she was saying seriously. Because every time I would ask, okay, let's do this, she'd bring a stipulation on board.
Submit 10 over the objection.
11. So again, similar thing. I think this is around the same time. She said she'll tell Rabgen that we don't want the appointment next week. But I couldn't be more steadfast in my decision not to take it early without the stipulation. So again, the stipulation is the only way, as she says here, and then she says, anyway, I hate to go to the press, but that was your decision as well, and I respect it. And then she even says, she tries to talk about making an offer on a property for real estate, but so again, I don't understand why, as clearly there's no relationship here or any interest in me wanting to talk, but yet she was trying to have any type of discussion with me. But again, she says here stipulation is the only way to do the test, and so I end up blocking her again.
That was mid 11 over objection.
12, again, this one, she said she wants to do the test. I then said, you want to do the test and the stipulations? She said, you're going to be forced by the court to meet up with me. So the second I found out that she, again, I asked, she'd do no stipulation. She ends up saying, you have to meet up with me. And then she says down here, I said, you're willing to meet up in a very public place. You will take the test afterwards. She said, no, it's with a week worth of stipulations and hopefully more. So again, she stated that after she said she wants to take the test, she then confirmed that she was not willing to take the test unless the stipulations were added.
I'll admit 12 over the objection.
13. So again, another message from Laura, different number. I asked her if she'll meet up with the court with the mediator present. She said that's not how it goes. We can meet up just us, and I will withdraw the request for sanctions. And then again, I said, would you meet up in a public location? This thing was cut off. It was in another text message, but she ended up disagreeing to or not being willing to meet publicly. She said we had to meet privately, and so then I blocked her on this phone number as well.
I'll admit 13 over the objection.
Okay. How am I doing on time?
You have about 10 minutes.
That's okay.
Maybe 15 minutes.
I want to skip now. I want to make sure I get to the ones that I really want to talk about.
Mm-hmm.
Okay, so Exhibit 15. Laura sent me a very alarming message stating that she was going to kill herself if I do not remove it was a video that I posted to my Instagram. So Laura has claimed that my responses online are meant to defame her, but that is not the case. Laura decided to leak this story to the Sun originally, and she leaked it with her as anonymously, so she did not place her name out there. But what she did do is she mentioned to them that we had an active court case. So that active court case, she is the one that brought that against me. In that court case, her name was on the court documents. So she ended up then bringing that, once this was leaked to the Sun, they submitted the story, and then it stated that within that document that there was an active court case with me. People then searched my name and found her name through that. So this email right here, she was basically threatening me to take down my video. In my video, I just stated that this individual was making these claims. I just made a statement of the facts that they were making these claims, and they opened the court case against me. And then from there, I do have a large following. I am a public figure, a celebrity, I suppose. I don't like that word. But I have a large following, and then that audience, I cannot control what they do. But they then went and found that court case in the system and found her name, and then started to talk about her online. And then Laura, I assume, was feeling the pressure from it being online and her name being out there. She then sends me this alarming message, which again I felt was harassing, but to threaten to kill herself. I don't think anybody should ever receive a message such as that.
All right.
Your Honor, I'm going to continue to object for the same reasons that the other exhibits 2 through 11, actually 2 through 13, for the same reasons. I don't think that, again, this is showing that this is harassment by sending an email to him, asking him to take down posts, or saying that maybe she is suicidal. And for those reasons, I'm requesting that this not be admitted into evidence.
All right. I'll admit 15 over the objection.
Thank you. Come back to that. Let's see. I just want to make sure if I have some run out of time here. I will jump ahead here just to Exhibit 23. So Laura has contacted multiple nonprofits that I work for in attempts to defame me and basically get them to not work with me. So in this email here, she sent this to the Arizona SPC. This was I just spoke actually at this HOPE conference. I'm a mental health advocate. And so Laura began to blackmail me and reach out to individuals that she had seen that I interacted with online. So I'd like to admit this as evidence that, again, she was harassing me through reaching out to individuals close to me in attempts to defame me.
And how did you get this? It was sent to you as well?
She copied me on the email.
Okay, and when was this sent?
This was sent on August 3rd, 2023.
Okay. Any objection?
Yes, Your Honor, I'm going to object because this appears to be an email that Mr. Echard was either to or CC'd on that indicates Laura's reasoning for why she believed that he shouldn't be a speaker at this conference. Again, this isn't harassment, and it doesn't seem like it was directed toward him. It was directed, although he was CC'd in the email, or he was in the email, it was directed to the HOPE conference in relation to whether he should be speaking at this based on what was going on and his credibility. I don't think this would be appropriate to be admitted in this case. This wasn't directed toward him for harassment purposes, and so this shouldn't be admitted.
All right. I'm going to admit 23 over the objection.
I would like to now go to Exhibit 26. This email was sent by Laura threatening to sue me, again, with the videos that I was posting in order to protect my own image. My image is how I make my money, and I make my money online, mental health advocate. Also, being a public figure, I have brand deals and such and companies that I work with. So everything that I'd stated, I've never once mentioned her name in public. And then in this email, as I put up a video to protect my own integrity and protect my own reputation, Laura threatened to sue me with a massive lawsuit and stated she had an unlimited budget to sue me, which I felt was very harassing in nature.
Is this the same video that was the previous nature of the other email that she was asking to take down? Or is it something?
I believe this one was. To be honest with you, again, I put up a few messages or videos. I believe that was referencing that video, where again, I believe it was either that, but to be honest with you, I'm not sure if it was that one or if it was the one where I stated I had scheduled a prenatal paternity test and I was waiting for her to schedule her portion. I submitted I think I put 3 or 4 public statements online, and every time she had threatened me to take it down or face legal action.
Any objection to 26?
Yes, Your Honor, same thing that I've been objecting for this entire time. I don't think that this email specifically shows that she was trying to harass him. I don't think that it's relevant to the petition, and for those reasons, I don't think this should be admitted.
I'll admit 26 over the objection.
Thank you. Anything else? I guess I will go to Exhibit 19 now. This is, again, another email that I was copied on. Laura had sent this to my father, sent a long email basically saying that I blocked her and that, hopefully he could get through to me and get me to end up talking with her. So I want to admit this just to show that she went to many various different avenues, friends and family, in order to bring light to this and put pressure on me to then interact with her.
Different objection to 19.
This isn't directed at Clayton, Your Honor. This is directed at his father. It's an email to his father. Mr. Echard's father is not indicated in this petition. He's not here today. I don't think that this should be admitted for those reasons.
It does appear that Mr. Echard was copied on the email as well, so I'm going to admit 19 over the objection.
Thank you. I'd like to look at
About 5 more minutes.
Okay, thank you. I'd like to look at Exhibit 16. This was an email sent to me from Laura, and basically in this is Exhibit 16 and 17. They came within the same email. She stated that this is the photo I'm going to use. It was a picture of 2 pieces of clothing saying Echard twins coming February 2024. In this email, she said, "Surprise! I can't wait for the arrival of these 2 next Valentine's Day," which I don't know how she would, know that she'd be due on February 14th. But she stated then that on a more serious note, their father said he wants nothing to do with the process. He has blocked me. Tag him and let him know what you think. This was a threatening email where she was stating, if you want option A, and option A had to deal with dating her. She said, "I will not post this. I'm just looking for support during this incredibly overwhelming time."
And when was this sent?
I see that it says yesterday, 2/23. So I wish there was a timestamp, but I believe this was earlier. This was probably 3 months ago. It was towards the beginning. Again, this has been 5 months ongoing, but this is probably 3 months. And at this point, this is before she had not leaked the story to the Sun at this point.
Any other objection to 16 or 17?
Objections to both for the same reasons stated before, Your Honor.
All right. I'll admit 16 and 17.
Thank you. I'd like to focus on Exhibit 21. So this shows a process server that Ms. Owens hired to serve me papers when I went down to Miami to visit my cousin. She knew that I was down there, and she had researched women that I had interacted with or expressed interest with in the past, found that these 2 women lived in Miami. I didn't even know that Mrs. Jessica Gerard even lived in Miami. but I did not go to see either of them. But she had a process server try to serve papers to both of those residents, which I felt was very harassing in nature, as these individuals I have not been in contact with for quite some time, and I believe it was a display of power on Ms. Owens' part to, again, harass me and try to get other people involved. And so I'd like to admit this because I felt that, again, it was very harassing in nature that I had a process server trying to serve papers to individuals that I expressed interest to in the past. It didn't seem necessary, as you could have just served the papers in Scottsdale.
Yes, Your Honor. In almost any lawsuit, there needs to be service of process. That's how a lawsuit begins. That is for personal service. The court has jurisdiction over the person. Nobody likes to be served papers. I don't think that this shows any amount of harassment. This was the process server emailing Mr. Echard, my client isn't even on this email.
All right, so I'm going to sustain the objection as to 21. I'm not going to admit that one.
I guess I can just admit this last one. Exhibit 35. This was sent on Friday of last week. I took a screenshot of it. This was after Ms. Owens filed a order of protection against me. And as I've never threatened her, I believe I have not ever threatened her, but yet she continued to contact me. So this was, I thought, again, she was asking to go to a sonogram appointment, and it would mean a lot to me if you would go. Again, I think all things considered, the fact that she's still, I had no interest in wanting to meet up, and she was still sending me these messages after she placed an order of protection against me. I think it just more so shows that the reason she sent an order of protection, it would not make sense as to why she would want to meet up after that point. Again, this felt threatening because just another message that she continued to send. And I just didn't, again, I've been not wanting any of these emails to come over to me.
Any objections?
Yeah, Your Honor, same objections as before, but at the same time, this is outside the scope of even this petition.
And I do think we're restricted to kind of the petition since this was happened after the petition was filed. I will sustain an objection and not admit 35. Record, if there's any other testimony you want to give as well, just outside of exhibits that you want to let the court know, you can also provide other testimony.
Yes. Is this the time for me to ask for a request from the court, or as far as what I don't know how to say it.
I'm not sure what that is, but you can.
Again, I guess I'll say this.
And you'll have a time to do a closing, but if you have additional evidence or anything else you want to present, just that's what I'm looking for you to do. But if you have a specific question, you can ask that as well.
Okay. I guess I just want to state, maybe this will be better for my closing statement. I guess I don't have any questions at the moment.
Okay. And no other evidence you wanted to present?
For the sake of time, I know that I ran out. I could try to submit the rest of these, but I think I've run out of time.
All right. Thank you. Any questions?
Yes, Your Honor. You were Laura's real estate agent, is that correct?
I was for a brief period of time, correct.
Okay. And that was earlier this year, is that correct?
Correct.
All right. And back in around May of 2023, you and Laura had become intimate, is that correct?
Correct.
And since then, Laura has made it known to you or has claimed that she's been pregnant, is that correct?
That's correct.
And you have, even until this day, you've refused to believe that Laura is pregnant, is that correct?
I would say that's not correct. I did question, yes, if she was, but I have tried to give her every possible option or ability to prove to me that she's pregnant. She's not allowed me to talk to any of her medical examiners that have administered the quote-unquote ultrasounds that she has done.
Okay, and she isn't required to give you her health information, is that correct?
I personally would say that when she's claiming I'm the father, that the father of her alleged children should be able to have access to her medical records, especially when it's pertaining to pregnancy.
But it is true that at the beginning, back in maybe May or June, you did not believe that Laura was in fact pregnant. Is that correct?
Yes, I have questioned if she's pregnant.
Okay.
Correct.
You have exchanged emails or text messages with Laura indicating that you did want her to get an abortion. Is that correct?
I had stated that if my preference was to not have children with her, but it was ultimately her choice, and I was not going to pressure her.
And those were communications that you had back and forth with Laura in text messages. Is that correct?
Yes, we had interacted via email early on.
Okay. But had you also interacted with her in text messages?
Yes, as evidence I've submitted, I did respond to her early in the messages.
Now, you agreed to meet with Laura or have Laura come to your house to do a pregnancy test. Is that correct?
That's correct.
And Laura did come to your house to do a pregnancy test, correct?
Yes, she ended up doing one when she was there, yes.
Okay, and that test showed that she was in fact pregnant. Is that correct?
And showed that she had HCG in her blood, yes.
Okay, and when you all agreed to do that, you were communicating back and forth with Laura, correct?
Correct.
She didn't just show up at your house, correct?
Correct.
You questioned then not only whether she was actually pregnant, but then whether you were the father. Is that correct?
That is correct.
And Laura went out of her way to schedule various paternity tests to show that you were the father. Is that correct?
For that, I would say she was claiming she'd scheduled them. She did schedule a few, but then whenever I did not agree to her stipulation, she canceled them.
Okay. So she scheduled a few. Is that correct?
I believe she did, yes.
Okay. And it was her that did the scheduling. Is that correct?
Until I scheduled one, yes, that she and I took recently, which came back little to no fetal DNA present.
Okay. The communication between you and Laura for the scheduling, was that through email?
Yes, mostly it was over email at that point, correct.
Some of it was through text messages, is that correct?
I had asked for her to schedule them via text. Yes, I believe that, yes, I mean, as you saw in the exhibits, I had asked for if she would do it without stipulations.
Okay. And so there was communication back and forth between you and Laura, is that correct?
But yeah, it's very limited overall considering the frequency of the messages she sent. But yes, at certain points I was trying to work this out with her.
Okay. Now, the text messages and emails that you've provided to the court today, those are not all of the text messages from you, and of course they're not all of the text messages from her. Is that correct?
That's correct.
And same thing with the emails. That's not all the emails from her. It's not all the emails from you. Is that correct?
That is correct.
Okay.
I would not be able to submit.
I don't have a question. Now, Laura, you at some points in time stopped responding to Laura, whether it be through text messages or emails. Is that correct?
Yes.
And this is also around the time when Laura was trying to schedule the paternity test. Is that correct?
I stopped responding, and then she started to state she wanted to schedule a test. Just she was claiming she wanted to, but she would never, whenever it came down to me wanting to schedule it with no stipulations. So I stopped responding at a certain point when I realized that she would always keep adding the stipulations in. From that point forward, she was making claims she wanted to schedule them. It didn't mean anything. She had already proven that she had no interest in actually following through.
Was there a time that you're aware of that Laura hired an attorney to help schedule the paternity testing?
I had spoken with one of her attorneys at one point, and they had shown me the ultrasound that I had admitted here, and I asked for them to subpoena the records or to get the records from that ultrasound. She would not provide it, and then stated that I asked her if she would schedule without stipulations, and the lawyer told me she would not.
Okay. Laura paid for you to have or to do some sort of blood test to determine, to do your part of the paternity testing. Is that correct?
As I referenced in my exhibits, she did make a payment, and then when I would not do it without the stipulations, she canceled.
She canceled or you canceled?
Canceled. Somebody canceled my portion. It was not me. It was I. They called in and tried to cancel my portion, in which case I found that out, and that's what led to me scheduling it and then going online to make a statement so everyone knew that I was trying to do this paternity test. I did not cancel it, though. Absolutely not. Somebody called in and canceled it for me because our names were under the same test.
You're stating that somebody canceled a paternity test on your behalf, and it wasn't you, and you didn't authorize that?
That is correct.
Now, you and Laura have an active family court case together. Is that correct?
That is correct.
And it was Laura that filed that case against you. Is that correct?
That's correct.
And this family court case is in regard to paternity. Is that correct?
In regard to a parenting plan, she filed for a parenting plan.
Okay.
The children that have not been proven.
All right. And you're not represented by an attorney. Is that correct, in that family court case?
That is correct.
Okay. And is it your understanding that she, at least at the time, wasn't represented by an attorney in that case?
I understand the purpose of that question, but I don't. But I've spoken with lawyers. I believe that she filed in that case, though, as representing herself.
Okay. And the court ordered that you guys meet and confer. Is that correct?
For an early resolution conference virtually, but not to meet in person. That was never sent to me, although she claims that the court mandated that.
To resolve different issues prior to that conference. Is that correct?
The court did not mandate that. I never was told by the court. I was told to show up to an early resolution conference. She said that we were supposed to, if able to. Apparently the court asked that individuals try to resolve all matters, but I had no interest in doing that because I did not trust her if we were to meet up one-on-one, what she would accuse me of. Okay. But she emailed you or texted you in regard to trying to resolve those issues before showing up to the early resolution conference. Is that correct? Claim that we needed to meet up to discuss matters. What specifically I was not sure of.
Now, you have accused Laura multiple times of lying that she is pregnant. Is that correct?
That's correct.
And you've done that online. Is that correct?
I believe in a video, again, I never once mentioned her name. I believe I may have said I questioned whether or not she was pregnant.
Okay, so you insinuated that she was lying. Is that correct?
I believe she is lying, yes.
And the different media outlets that have you spoken to media outlets about this?
I early on provided statements to a couple of outlets to state that I did not believe that I was the father, and that I was hoping to do a prenatal paternity test in order to prove whether or not I in fact was.
Okay. And up until recently, you hadn't done a paternity test. Is that correct?
Yes, but that was because of Ms. Owens was not willing to do one as I asked her to as far back as 4 months ago.
Okay, so you're blaming Ms. Owens for not doing a paternity test. Is that correct?
Correct.
And that's why you wouldn't do a paternity test?
I could not do one because she would not do one. She would not do it unless I were to date her. Those were her stipulations.
Now, you indicated that you spoke to the media about this, and they published those statements online. Is that correct?
There were a few outlets, yes, that published my response. Yes.
And the results of the paternity test are not resolved. Is that correct?
I was told that little to no fetal DNA was present on the first sample and that she needed to submit another sample.
So the results are not in yet. Is that correct?
Yes, I suppose that is correct.
Now, you had indicated that Laura had blocked you several times. I apologize. You had indicated during your testimony that you had blocked Laura several times from various numbers. Is that correct?
Yes.
Okay. But you were in communication with Laura this entire time since May. Is that correct?
I would not say that's correct. I was not in communication the entire time. If I were to be able to show all of the exhibits, I probably responded to maybe 5% of what she has sent to me.
Okay. I'd like to take a look at Exhibit 4. Plaintiff's Exhibit 4. You had indicated that this was a text message from Laura to you. Is that correct?
Yes.
Okay. And you had responded to Laura in this particular text message. Is that correct?
Correct.
Okay. Is that the same thing with Exhibit 12 and Exhibit 13? You had responded to Laura after she messaged you?
If there's a text bubble, as I'm trying to look here for the sake of respecting time, if there's a text bubble, then yeah, I was the responder in those messages.
Okay. And in all of these text messages that you submitted to the court, did you ever one time tell Laura to stop texting you?
Multiple times I asked her to stop communicating with me.
Okay. I'm asking in the exhibits you submitted to the court and in your testimony, you not one time ever said that Laura stop texting me or stop communicating with me, did you?
I'd have to go back at the exhibits that I directly submitted, but I've asked multiple times for her to cease communication. I know you're asking for me specifically if I stated this in the text messages, but I can absolutely confirm I've asked her multiple times to start responding to me.
Okay.
And I have evidence to prove that, maybe not on these text messages alone, but again, I have 500 exhibits I could have submitted.
And isn't it true that you indicated Laura threatened to go to the media regarding this, correct? You had indicated that Laura had spoken to you via email or text message that she was willing to go to the media to discuss what was going on between you and her. Is that correct?
Yeah, she stated she was going to go to the media, yes.
And didn't you email or text Laura indicating, go ahead? Essentially, go ahead, you can talk to the media.
I believe I did state that at one point, because my reasoning for that was because I knew she was trying to threaten me and scare me by going to the media, and I did not want to give her the joy or whatever you want to call it of knowing that she was affecting me. So I just stated, sure, if you want to go to the media, go to the media. But I was not giving her permission. I guess I wasn't agreeing to it. I just knew it was inevitable. She was threatening me.
So you consented to it?
I wouldn't say I consented to it. I wanted to resolve this privately, very, very early on, multiple times. And as I sent some of these exhibits show, I was trying to. She had threatened to go to the media multiple times, and at that point, after she had threatened me multiple times, I stated, "Go ahead," just simply because I knew that she was going to continue to threaten me, and she would eventually go public.
No further questions.
And you have an opportunity to provide rebuttal testimony if you want to, based on what he's asked you. If you have anything else you want to help clarify.
Yeah. Again, I think what he's trying or what he's attempting to show is that there was continuous communication throughout, and I believe again this is a matter of frequency, my messages versus hers. I was continuously trying to solve this matter, and the few times that I did reach out, I was trying to come to a conclusion. Again, had I actually been the father and the prenatal paternity test was done 4 months ago, I was willing to take the test back then and willing to then move forward from that point. But this individual, Ms. Owens, never had any interest in settling this matter. This again, as I had referenced in our prior cases, this individual, I believe, again, this is just my opinion, but, harasses individuals into dating her. And when they do not want to, then she starts to say that she's not willing to take a test, or at one point it was, I'll take Plan B or the abortion pills if you agree to date. So there's always stipulations around that. But the few times where I did respond to her, it was from me trying to get a prenatal paternity test on the books, because I was wanting to be able to prove that I was not, in fact, the father. Through all of this, I just want to make this statement. Ms. Owens has not been able to prove that she is 5 months pregnant with twins. A positive HCG test, you can manipulate HCG levels. These sonograms don't have a report with them either. And so no doctor has ever stood behind these tests and been willing to state that she is, in fact, pregnant with 5 months pregnant with twins. And so
No, I'm going to object right now. This sounds like a closing argument as opposed to testimony.
Overruled. Go ahead.
So the whole thing for me is I've been trying to quash this. I've been trying to come to a solution. I never wanted this to be public. I never wanted this to get out there and be such a big deal, but this individual did and made sure that it got out. I would just, again, I would like the order of protection or injunction against harassment. I would like that because this individual is an aggressor, and if she will not continue to come after me, or she will continue to come after me unless I cut off communication. And so this is, whether or not I responded, it's the sheer frequency of unwanted messages that she sent me.
Tell me what that is. Tell me what you believe is the number of messages you've received.
I believe in that I believe she has sent me at this point 400 to 500 emails, probably.
That's over what period of time?
Over 5 months.
And is that including email and text messages, or?
Yes,
email?
She predominantly has sent me emails. And most of it was mostly email, not text message that she's been sending me.
The messages that you provided as exhibits, a lot of them were text messages.
Yes.
And so the other messages that you were receiving, I think Exhibit 1 has a big picture of all those, emails or whatever, but your testimony is that primarily she's been communicating you with by email. And tell me more about the nature of the emails that she's been sending.
Yeah, so as some of the exhibits I've admitted today, these are just the ones that I felt, again, I know that we're here for injunction and harassment, so I was focusing on messages that pertain to harassment itself. But the rest of the messages, again, were very repetitive. I think a lot of this is encapsulated as far as what she was sending me. She would send me visual images to try to harass me. She noticed that when she sent visual images, I became emotional, and then she would send more messages on top of that to try to aggravate me. I was not able to submit all of the emails because I would have submitted probably 500 to 600 exhibits. And so for the sake of time, I chose what I felt was specific to harassment itself. But I would say that, again, the first exhibit that I submitted, it just shows you with the folders the dates and how often she was sending me emails. And it was just every day, or every other day for 5 months. And I believe that this individual, again, her whole, she tries to overwhelm individuals through constantly messaging and trying to convince them of this reality that she has created. But again, as I will have to go to court tomorrow with the family court, she has not been able to prove she is 5 months pregnant with twins. And I continue to reiterate that because She has falsified medical records, I believe, and she's also lied under oath. And I believe these are criminal offenses, and I believe that this individual continues to do this in court, and that is why I've tried to draw parallels with the other cases, because she's done this multiple times, and I believe that she'll continue to do it. So I am trying to, for one, stop her from communicating with me, but I'm also trying to bring to light that this individual continues to do similar repeated patterns of behavior, and it has been extremely stressful. I have been very, very, very stressed out by receiving these constant influx of messages that could have all been solved had she had just took a prenatal paternity test all the way back at the earliest time that we were able to do so. None of this had to have happened. She didn't have to take it this far. But the point I'm making is she never actually wanted to take it until I went public and stated I signed up for a prenatal paternity test. Now she needs to schedule her part. I then placed that upon her to schedule her portion. And then as people knew that she had to schedule it, she then scheduled. But the test came back little to no fetal DNA present, which would track with her not actually being 5 months pregnant with twins, because if she had twins, then there would be fetal DNA present. She claims that there was an issue with the sample. She then submitted another sample that got caught up in Tennessee or wherever. It didn't make its way there. I can give my own opinion on what I believe happened, and I believe the message may have been intercepted, but I do not know that. But I know that when she tests again, it's going to come back the same thing. I do not believe, at this point, I'm not technically questioning that she's not pregnant, because I do believe she may have gotten pregnant to corroborate her story, but I 1,000% she does not believe that she's not 5 months pregnant with my twins. And that ultrasound that I have, she would not call the facility when I met with the mediator at the early resolution conference. She would not get on the phone and make a phone call to just state, did I in fact come to this facility? Because I believe she never went to that facility, and that is a falsified medical record.
All right. Anything, Mr. Lopez, do you want to present some testimony?
Yes, Your Honor. And before I present, how are we on time?
Fairly short.
How much time do we get?
I would say 20 minutes.
Okay. Could you please remind me when we're at 5 minutes? I appreciate it. Thank you, Your Honor. So, Laura, how did you first meet Clayton?
He was my realtor. I contacted his agency because they specialize in creative finance, and then I got connected with Clayton. I'm sorry, go on.
Did you become intimate with Clayton at some point?
Yes, I did.
And was it Clayton that, I guess, made you pregnant? Or the two of you that created these unborn children?
Yes, there's absolutely no possibility at all they are anybody else's. There's no chance.
And you're testifying under oath today, is that right?
Yes, absolutely.
Under penalty of perjury?
Yes.
Now, when did you find out that you were pregnant?
On June 1st, I found out.
Okay. And did you ever let Clayton know?
Yes, I let Clayton know on June 1st that I was pregnant.
How did you let him know?
Well, I had gone to urgent care to get the pregnancy confirmed because I figured he wouldn't believe me. And then afterwards, I sent him a text telling him that I was pregnant.
And how did he react?
He said that if he was found to be the father, that one of us would get 100% custody. He wouldn't do joint custody. He told me, or it will be put up for adoption, was what he said initially. And then he said that he might even move out of state with the children. And so I think it's understandable that I would be panicky about, what exactly he wanted done and why I was so into getting a parenting plan before they're born.
Okay, now let me just stop. This communication that you were having with Clayton, how was that communication? Through text, emails? How were you communicating with him?
Mainly through text.
And was he texting you back?
Yes, he was texting me back through about June 20th.
And prior to you becoming pregnant, was it your understanding that Clayton wanted to have a family?
Yes, it was.
Okay. And were you doing the things that you could do to inform him about the pregnancy and what was happening with it?
Yes, I was.
Okay.
Every step of the way.
What were those things that you were doing to inform Clayton?
Well, I invited Clayton and his family to my first sonogram with, he can't deny that I wasn't pregnant. I got into a specialist, a perinatologist, because I have epilepsy, and that was my first appointment. I know we have that in evidence as well, that he was invited. I even told his family if they wanted to come that I would change the date for them.
And what month are we talking about here? What months are we in when you're talking about these different things, the communication between you and Clayton?
July, because that's when I found out I was pregnant with twins, but in June, that was when I went over to Clayton's house and took the pregnancy test in front of him.
Now, during this time when you first informed Clayton, was it clear to you whether Clayton believed that you were pregnant, or did he not believe you, or what was that conversation?
I know that what he wrote initially was basically that he believed it, and because that's why he got into the custody stuff. But really, throughout this whole thing, I would say the theme has definitely been that he doesn't believe I'm pregnant, and I believe that's because he just doesn't want to take responsibility.
Okay. Now, you indicated there was a time that you went to his house. What was that in regard to?
I went to his house because he invited me over on, I believe it was June 17th. He invited me over saying he wanted to talk, and I agreed to go over to his house. And once I got there, I told him I would love to order a pregnancy test, and he said he already had one. So then I took the pregnancy test in front of him. I peed on the stick in front of him. It showed up positive pretty much right away, and he just threw away the stick and said he didn't need to see more. And then we talked about what would happen for us down the line, and he said he would, consider figuring out dating or whatever, because I don't think it's unreasonable to want to see if things can work with the father of your, what I now know as kids.
And let me just stop you. Now, were Clayton's intentions regarding the pregnancy and the unborn children ever clear at any point as far as what he wanted to do?
No.
Okay.
No,
so there was one, and when we say over, so is this over weeks or even months that we're talking?
Yes. Yes,
okay.
over months.
Okay. So was there a point when he wanted you to have an abortion?
Yes, there was.
Was there a point where he wanted to give the kids away for adoption?
Yes, there was, and all of that's in text messages.
Okay. Was there a point where then he didn't want anything to do with the kids and you have sole custody?
Yes.
Okay. And these are communications that you're having with Mr. Echard through text messages?
Yeah, those were through text.
What about emails?
Emails started later on, after we had the day after we had the conversation where I went to his house and took the pregnancy test. He and I were having a good conversation. Like, he messaged me in the morning. He said he wanted to be intimate that weekend, which I also have that text. And then an hour later, without me responding, he said God told him that we were not meant to be together, and he took that back. And then he blocked me, and I've pretty much been blocked since then. Okay,
so you would admit that you knew that Clayton had blocked you at some point. Is that right?
Yes, via text. Yes, I did.
Okay.
And he
but
told
then
me
would there be?
Go
ahead.
That's what I want to say is he told me to email him.
Okay. But were there times that even after he blocked you, he would then communicate with you through text?
Yes. He'd block and unblock.
So sometimes he would block you, but then he would unblock you?
Yes, and I think if you go to Exhibit 1, you can see some of the text messages that he sent to me.
Okay, let's take a look at Defense Exhibit 1, Your Honor, if I may. What is Exhibit 1, Your
Okay, well, it's not Exhibit 1 because obviously we have all of the plaintiff's exhibits. So you need to refer to the exhibit as it is on the exhibit worksheet, which I'm assuming the first defense exhibit I have is 40.
Oh, okay, Defense Exhibit 40.
I was only given 37, 38, but 39. I don't see any other exhibits.
It's titled Clayton, cruel and threatening text to me.
Your Honor, the exhibits that we had uploaded to the court, but I don't.
Were they provided to Mr. Echard?
I gave them to him on a flash drive right before the hearing.
Okay.
I did upload them, and it said it was successful, and that was on Friday or Thursday.
Okay, Ms. Owens, thank you. The court has the exhibits. My issue is that Mr. Echard doesn't have the exhibit. So I guess, Mr.
I could show them on my computer, Your Honor.
How we believe that he would be able to view those.
Well, I have them on my computer, Your Honor. I gave him a USB with the exhibits on it prior to this hearing.
Okay. I mean, prior to the hearing, like when you came into court today?
Yeah, I gave him the exhibits on a thumb drive. We had submitted the exhibits as the court wanted. I gave them to him electronically on a thumb drive, and I have them on my computer. I don't have them printed out.
Well, I guess I'm not sure how we're going to...
I have them right here on my computer.
I mean, I understand, but you're just going to show him them on your computer while you're talking about them? Is that what you're trying to do?
I'll let him access them with my computer, yeah.
Okay.
They're all in order. If you're saying it's Exhibit 40, then I guess we'll start there.
Okay, Mr. Echard?
I was just going to say, I mean, yeah, he gave me a thumb drive 20 minutes before we started this case, so I don't have my laptop with me. Nothing was submitted to me until today. I don't understand how, then I don't have any of it, so how can we bring it to light when it was never sent to me until 20 minutes before the case? And I don't have a computer to plug the flash drive into.
Yeah, and if I may, there are no disclosure requirements in these types of cases. The rules of protective order procedure, injunction against harassment, there are no disclosure requirements. Despite that, again, I gave him a flash drive before court today. I have the exhibits on my computer. He has access to them.
Okay. Well, the logistics of that seem extremely difficult to me when we're at 4:30 already. So we're already an hour and a half into the hearing. And so if we're starting to look at exhibits on your computer while you're trying to ask questions of her about them, I find that's going to be a bit of a difficult issue that I'm having with us trying to logistically all do that.
What does the court propose?
I mean,
again, I can show him my computer. The exhibits are here. I have them in order.
I almost think we need to reset for another, half hour of hearing where you can provide the exhibits, or he can have an opportunity to at least view the ones that you provided on your flash drive, and then we can discuss them as we're going to admit those.
I mean, we could do that, Your Honor, but then I'd like to proceed with the rest of the case just to use up this time, and then we could do that at another time if we need to.
I mean, that's fine. I'm just saying I think that exhibit issue, we need to try to resolve that. But if you have additional questions you want to ask her, that's fine.
Okay. So was there a conversation between you? Clayton was responding back to text messages that you had with him, correct?
Correct.
Okay. And same thing with emails during this time?
Yes, yeah. It wasn't like he stopped responding. And I also do have on MailTrack that Clayton opened every single one of the emails. I know he said he didn't, but I have proof he opened every one.
Okay. And the different exhibits that Clayton had admitted into evidence during his case, those were not the full text message conversations or emails between you and Clayton. Is that right?
Yes, that's right.
Okay. He was, in fact, texting you back and emailing you back.
Yes, that's correct.
And during the entire 5 months, or since I believe it's May that's indicated in the petition, Has there been one time that Clayton has told you, please stop texting me, please stop emailing me, or something along those lines?
No.
In fact, you had asked Clayton whether it was okay if you went to the media regarding this. Is that right?
Correct.
And what did he say?
He said, if you can tell, I'm completely unbothered by it. And I went to the media the next day. And I never wanted to go to the media. I just wanted to make a parenting plan.
Okay. Was there a time that you had to hire an attorney?
Yes.
And what was that in regard to?
I thought it would be easier for the two of us to communicate to try to get that parenting plan with an attorney and for us to avoid having to go to court.
Okay. Was there a time that you tried to do paternity testing with Clayton?
Yes, absolutely. Clayton was very unresponsive to that. And I paid $750 in August to have the testing. I asked him to email the lab to schedule his time because I already had a time scheduled. And he never emailed the lab, so that's why it was canceled. He had, more than a week to email the lab to tell them a date and time, and he didn't do that.
How many times did you schedule paternity testing?
I paid for it once, but I was in communication with the lab, RabGen, which is the lab that Clayton chose, about scheduling countless times.
Okay. And did he ever do any paternity testing, or did you do any paternity testing?
Not until recently.
Okay. And during this, you and Clayton were texting or emailing back and forth regarding scheduling of the paternity testing?
Yes, exactly. Exactly. And I didn't actually have to provide prenatal paternity testing by the court. I was doing it for Clayton's sake. I could have waited until they're born. Okay.
And was that the main form of communication between you and Clayton?
100%. Everything was about paternity and pregnancy. That was it.
But was it through emails and text messages?
Correct.
That's how the two of you decided to communicate?
What was that?
That's how the two of you decided to communicate?
Yes, was primarily through email.
You said something except for something.
Oh, except for in June when we met up. Other than that, it was just by texting and emailing.
All right. And it came to a point where Clayton wasn't agreeing to, or he didn't want to create a family plan. Was that your understanding?
Yes, that was.
And what did you want from Clayton?
I wanted to create a parenting plan because I was so unsure about, since he'd given me so many different options for what was going to happen, I really wanted it nailed down before I give birth as to what custody was going to be. And I wanted to see if there would be a possibility for us to do joint custody, not to be dating, but just because I think that would be the best thing for the kids, to not have 100% and 100%, or just 100%, I'm sorry.
Okay. And that wasn't possible to do prior to hiring an attorney and then eventually filing a family law court case. Is that right?
Yes, that's right.
But you tried to make that happen. Is that right?
That's right, yes. That was the whole point.
That was the point of the communication via text message and emails. Is that right?
That was entirely the point.
Okay. When did you file the family law case?
I believe it was August 1st.
And was there a point in time that you had to meet up with Clayton because of that case?
Yes.
And what did you need to do before that hearing?
Well, there were two things. I filed a motion where we were supposed to have a good faith consultation, and Clayton just didn't get back to me about that. And then we were supposed to get together before the early resolution conference to see if we could resolve the issues or resolve some of the issues without having to involve the court, I guess.
Is that, and when you received that information from the court regarding those things you needed to do before court, was it your understanding that you were supposed to meet up physically?
Yes, it absolutely was. It specifically said meet up, and he got the same information that I did.
Okay, so you were trying to meet up with him physically due to what the court had ordered.
Correct.
And you communicated that through text messages and emails.
Correct.
Okay. Now, did that meeting ever happen?
No, it did not.
Okay. Who was trying to make it happen?
I was the whole time.
Now, did you know what the penalty would be if you didn't meet up?
I was just going to say that. I did not know what the penalty would be if we didn't meet up, and I didn't want to face any penalties or get in trouble with the court when I was trying to abide by the rules. Yeah, that was all I was trying to do.
And the family court case between you and Clayton, that's still active, right?
Correct.
You guys are both unrepresented, is that right?
Yeah, correct.
So you're forced to communicate with him regarding some of these issues at least, is that right?
Yes, absolutely.
Scheduling and meet and confer, things like that?
Yeah.
Now, there was a paternity test that was done, is that right?
Correct.
Okay, can you tell me a little bit about that?
Yeah, so I took the paternity test on I don't know, it was earlier this month, I believe, and it came back within the sample, there was little to no fetal DNA, which I was told specifically by the guy who heads this lab that the testing was ongoing, but that was not a conclusive test, and that he needed to have me do a retest. And so but after that, I said, is Clayton aware of this, that the testing results are not final? And he said yes, and I do have that as an exhibit of him on the phone telling me that. But despite that, Clayton went public and said, we also have that exhibit as well, where Clayton boisterously said that there was little to no fetal DNA and I wasn't pregnant, which incited a tremendous amount of harassment towards me. And then after the sample...
Let me stop you really quick.
Oh, sorry.
Stop you really quick. Now, during the paternity testing, did you have to communicate back and forth with Clayton regarding results or what was going on?
I tried to, and he would not respond to me about it.
And is that when he went online?
What was that?
And is that when he went online to indicate what the results were?
Yes. Yeah, and that's what...
There were no results?
Yeah, there were no results. Testing was ongoing.
Is it still ongoing?
Yes, it is still ongoing. They just needed a sample that wasn't so diluted, and so they asked me to come back. I took a test a couple weeks ago. I think it's crazy that Clayton's acting like I somehow intercepted that sample in Tennessee. It ended up, I guess, getting stuck in Tennessee and getting delivered in 2 days instead of one to the lab, which meant the sample was no good. And then I went today and I gave blood again. But that's my third time giving blood. It's not my fault, at all.
Now, aside from texting or emailing Clayton regarding the pregnancy, the paternity test, this family court case, was there anything else that you had emailed or texted Clayton?
Not a single thing, and he knows that as well.
What about the posts online?
Well, that was related to the paternity. I did message him after asking him to take that off when I started getting people telling me to kill myself, and people were posting terrible reviews on my podcast. I was getting horrible messages on my Instagram. I had to deactivate that. And I begged him, please take this down. The results are not back. Here's Brett from RabGen explaining that that the test results aren't back. You can't be posting this kind of stuff and inciting harassment against me.
And is that because you're understanding Clayton's fans or Clayton's followers were harassing you online?
Yes, and they were naming me in his comments and giving my handle out, my Instagram handle out.
Okay, and those were because of Clayton's posts?
Entirely because of Clayton's posts. And then on Reddit, I mean, I can't even go into the what people have said about me on Reddit as a result of his post, which I mean, I'm clearly pregnant, and I, will do anything to prove the paternity. And so it's just all of this information that he's put out there that's false has been so upsetting to me.
But you had reached out to Clayton regarding those posts and asked him to take it down after you were receiving these harassing emails or messages online?
Correct.
Okay. Now, was there a time that you had reached out to somebody who Clayton was going to speak, somewhere where he was going to speak?
Yes, I did.
And what was that?
5 minutes.
And what was that?
I contacted them because I was feeling suicidal as a result of Clayton's actions towards me, and I'm sure, I'm hormonal because of the pregnancy and not knowing, what the plan is going to be going forward. But I felt that it's strongly in my heart this was not to harass Clayton. I just felt that if Clayton was the kind of person who would not respond to me knowing I was pregnant with his kids, then there's no way Clayton would respond to somebody else who reached out to him saying they were in need and that they were suicidal.
Okay, let me just stop you. We have about 3 minutes.
Okay.
So, Clayton had brought up instances of other cases that you're involved with other individuals. Is the current case that you're involved with Clayton with similar to any of the other cases that he's brought up in his exhibit?
No.
Okay. And that's an ongoing case, is that right?
Correct. It's been going on for 2 years, and that attorney dropped out of the case. There was never an ultrasound presented to him. I was too early on, but the pregnancy was proven to him by a nurse practitioner, by tons of medical results. I can prove that all day long.
Now, in the communication that you had with Clayton, were you ever trying to threaten him or harass him or annoy him in any way?
Absolutely not. Absolutely not. I mean, I would think he would want a parenting plan as well.
Okay. Your intent during this time was essentially to get the parenting plan then and get this all figured out before the unborn children are born.
Yes, because I'm panicked about having twins and not knowing if he's even going to, he specifically put on that he didn't want to even be on the birth certificate and didn't want to give them his last name. So.
No further questions, Your Honor.
All right. So I'll go ahead and stop here, and then we'll pick up because you may have some questions still for her about the exhibits. If we're going to pick up again, I'm assuming that there may be some exhibits that you want to.
Oh, yeah. When I said no further questions, I just meant.
Yeah, for now. Yeah, no, I understood. That's why. We're going to take a break now, and then, Mr. Echard, you have the exhibits now in your possession. Is that correct? Obviously not.
Flash drives.
So you have the flash drive, so you can do that to see the exhibits, correct?
Yes. Are we going to do this today? I would like to come to a conclusion today as far as how we're going to proceed.
Well, I don't think that we're going to be able to finish it today, because we're already at our time. Past our time, really, for doing the trial, and we haven't done their exhibits yet. And so I want to give them an opportunity to do their exhibits, but I can try to find another date to see if we can come back and finish up the hearing.
I have the ability to ask questions to her.
You will once she gets done with her testimony, so I'm going to give them still time to do some of their exhibits and questions, but then you'll be able to cross-examine her.
Okay. Great. Is there a way to request for her to cease conversation via all avenues until this next hearing?
I don't know if there's a legal method for that.
I would just ask or make a request that she stop sending me messages. I don't think that it's maybe it's just, I don't think it's worthwhile. It's not necessary, considering we're under, in a court case. I don't know if I can request that, but I would like to request that so that we can avoid having conversations outside of the court anyways.
Well, Your Honor, they have an active family court case right now, and this type of hearing specifically is for what Mr. Echard is asking for. That's why we're doing this hearing, and I don't think the court can order that my client, not saying that she would, but I'm just indicating that I don't think that this court can order her not to have any contact with them at this point. They have a family law case together. We actually have another protective order hearing tomorrow. I don't think the court has the power to do that, and I don't think that request should be granted.
I don't know that I can do that officially. I think that we can note Ms. Owens hears your request and is asking that you cease any communication between now and when we are able to redo our hearing, unless there's a need to do that, specifically for the family court matter. But I'm assuming you would communicate while at a court hearing versus outside of a hearing. So let me look for another date.
Okay.
Your Honor, is it possible for me to show Clayton that I am in fact pregnant because he hasn't seen me?
No. I can do either the 26th, which is Thursday at 11, or I can do the 2nd at 11.
26th of this week, correct?
Correct.
Your Honor, I'd be requesting the 2nd, if that's possible. I do have a criminal trial at 8:30 in the morning on the 26th. That should be going at least all morning. That's out of the Phoenix Municipal Court.
It's November 2nd at 11 work for everybody then?
I would request the 26th. I don't want to drag this out longer than it needs to go. So if it were, if I may, I would like to ask for the 26th so that we can forward in a quicker manner.
And I understand. I just think if he has a court conflict, I'm not sure of an aesthetic. I know he has a court conflict.
Is it possible, like, if the court has time in the afternoon, like 3 o'clock on that Thursday night?
I don't have another injunction trial that afternoon.
I guess my question is would your court case not have an end time? And if so, what is that time?
Well, usually, just like in a criminal trial, it's usually 3 hours. So, it'd be kind of like this. So, the court's saying 11. Is that what you said, Your Honor, like 11 or 11:30? And
11 is when I can do it.
Yeah, and driving from Phoenix to here, that's going to be a minimum of 30 minutes. I wouldn't be able to finish that.
Driving from Phoenix.
But even assuming they start at 8:30.
Okay, so it's supposed to. I'm not trying to be difficult. So you're saying it's supposed to start at 8:30.
That's correct.
And it's scheduled for a 3-hour time limit. This has a time limit on it, so it's scheduled for 3 hours.
Yes.
Okay. Oh.
Right, so November 2nd at 11. We're going to pick up with the exhibits, defense exhibits, and then we'll allow Mr. Echard to do cross-examination, and then Mr. Echard, you would have the opportunity to present any rebuttal testimony if you felt that was needed.
Thank you, Your Honor.
All right. Thanks, everyone.
Thank you.
Thank you. We'll get an email for that, or just confirming 11? Okay. Thank you. with me, or?
You can take out your copies of them. We have the court exhibits, so.
Okay.
USB is the same one. Okay. You guys got mine. Bill. I did. I didn't through the court team, yes. Okay. Okay, yeah, same as mine. And I apologize. I didn't.